McNamara.
Thank you, Chairman. At the outset, I wish to state to the House that I'm a member of the Law Library. I'm a barrister at law. And however, I also wish to state categorically to the House that I appear today as on behalf of my constituents in Clare and not on behalf of the Bar Council or indeed on behalf of barristers. I would commend much of what the previous Speaker, Deputy Creed, has said. There are undoubtedly many problems with legal services in this state today, many problems with how the solicitor's profession is run, and indeed many problems down at the Law Library, problems which previous governments for generations, decades, even perhaps centuries have shied away from dealing with. And I commend the Minister for finally dealing with this issue head on. However, I suppose there are elements in this Legal Services Bill which I have grave concerns about, and concerns about as a representative of the constituents of Clare. There was a report last week in the Examiner newspaper which stated that some solicitors are charging up to 6 times more than others for the same basic services a price survey by the National Consumer Agency shows. Well, Minister, that comes as a great concern to me, as I'm sure it does to my constituents, as I'm sure it does to you. However, the question that I would ask is, at the end of the reform process which is envisaged in this bill, will it be the solicitors who charge 6 times more or the solicitors' firms who charge 6 times less that will still be operating? And I fear that it is quite unclear from the bill which it will be. I actually fear that it will be the solicitors who charge the 6 times more, because as Deputy Creed said in the previous submissions, that we have many solicitors in small town Ireland who operate with very low legal overheads. On the other hand, we have large solicitors' firms here in Dublin, predominantly in Dublin, I suppose also to a slightly lesser extent in Cork, and also in Limerick and Galway, who are much larger firms, who operate with far greater overheads, and who by and large, it has to be said, charge a lot more per hour for the same work. That is why the great majority of people in Ireland go to very small firms with their legal problems. They go to very small firms to have their conveyancing done. They don't go to the big 5 with their problems. However, Minister, I fear that the proposal to allow multidisciplinary bodies will force those small firms out of operation, because they won't any longer, when a complex case is brought to them in Scariff, in Kilrush, Diamond, they won't have access to former Attorney Generals at the bar. They won't have access to senior counsel. Instead, somebody with a complex case will have to go to one of the big commercial firms, will have to pay the large overheads. So it is, while I clearly acknowledge that something has to be done and urgently has to be done about the fact that some solicitors' firms charge 6 times more for the same work than others, I fear that this bill doesn't currently address that problem, or doesn't make clear that it will be those small firms will indeed be able to survive. Undoubtedly, fees paid to counsel over the years, particularly counsel engaged in tribunal work, have cast the legal profession, in particular the bar, in a very bad light. Nobody in this House, or indeed I think very few even in the Law Library, other than, of course, maybe those who receive those fees, could actually stand over them. But that doesn't change the fact that there are very many barristers who don't earn as much, who earn actually very little. And, you know, even in places like Clare, there are people who wish to become barristers. Even in places like Clare, there are people whose ancestors, whose family are not of the legal profession, who believe that they can become barristers, who would like to become barristers or lawyers, and who believe that they have the right to do so. But again, Minister, I fear that this bill, in introducing multidisciplinary teams, will actually privilege children of privilege. Because what determines how one gets in to one of these great multidisciplinary teams? Well, I think the same factors that determine who gets in to a chambers in the United Kingdom. Do we wish to return to the days of before this date, and indeed to a large extent up to now, where only persons of privilege can aspire to becoming barristers, can aspire to becoming senior counsels? I expect not, and I don't believe for a moment that it's the Minister's intention that we should do so. My colleague, my Labour Party colleague, indeed my colleague at the Law Library, Willie Penrose, spoke from these benches about his personal experience, how he managed to become a barrister, notwithstanding by his own proclamation, humble background that he came from. But I would say that persons like my colleague, Willie Penrose, persons like myself indeed, are quite rare down at the Law Library. It's very rare to sit in court in Limerick and hear a working class Limerick accent other than in the dock or giving evidence. It's certainly very rare to hear somebody addressing the court from the barristers' benches in such an accent. The same is true in Clare and the same is true in Cork. But, Minister, this bill does nothing to address that. And it is, I think we would all agree, something that needs to be addressed. A recent report in the Irish Times pointed out to the fact that the number of barristers leaving the Law Library is increasing, and a further sharp increase is expected. But, Minister, it's not the children of privilege who are leaving the Law Library. It's not the children whose families can provide them with the independent means to survive the first 5 years, the first 6, the first 7, maybe even the first 10 years before they start earning a decent income, and subsequently perhaps too great an income, who are leaving. It is those who come from ordinary families. It is those who have to make their own way in the world who are being forced to leave the legal profession. And I don't believe that that is healthy for the legal profession any more than I don't believe it's healthy for our society to have this practice. Minister, much was also made of the independent referral bar in many of the contributions that we heard from both sides of the House, the importance of the independent referral bar. But, Minister, I don't need to bring it to your attention, but I have to bring it to the attention of the House, that there are a group of lawyers who don't operate that taxi rank rule, and they are the lawyers who represent the Minister for Justice in immigration cases, because they are not available to applicants. They represent the state and only the state. They must undertake not to take work from applicants in order to work for the state. Now, Minister, I have grave problems with what that says about our immigration system, but I have even graver problems still if the membership of the authority which will govern the combined professions will be appointed by the government, albeit from non-legal backgrounds. They'll be appointed by the government. And even more under Section 8 of the proposed bill, and of even greater concern is the Complaints Committee proposed in Section 50, which will be appointed by the authority having been appointed by the government, with the approval of the Minister. So, if I or one of my constituents, and there are barristers among my constituents, as there are among yours, Minister, have the audacity to take a case against the Minister, well, and fall foul of the Minister's chosen legal representatives, well, how will they achieve a fair hearing? It offends the very most basic principles, in my view, or potentially offends them. Nemo iudex in causa sua. Let nobody be a judge in their own case. But the ministers appointees would end up adjudicating in a dispute, potentially, between the minister's chosen legal representatives and somebody who has the audacity to perhaps challenge them, because nobody's perfect. I think not even the minister would claim to be perfect. No professional is perfect. So that is a concern that I have. Now, we've been told that the reforms envisaged in this are necessary because of the IMF and the Troika bailout, let me just read into the record of the House what is in fact required. The Government will introduce legislative changes to remove restrictions to trade and competition in sheltered sections, including the legal profession, establishing an independent regulator for the profession. Minister, I have no problem with an independent regulator. I do have a problem with a regulator which is dependent upon the Government. And implementing the recommendations of the Legal Costs Working Group and outstanding Competition Authority recommendations to reduce costs. Well, Minister, if the Minister did want to go down that road, then I suggest that perhaps the Department of Justice could start a lot closer to home, because in order to be a barrister operating in the criminal legal aid scheme, which my colleague Deputy Creed mentioned, the procedure for barristers is that they must inform the Bar Council that they are willing to accept instructions, and the Bar Council then informs the Minister's officials. But there are, in Ireland, the Republic of Ireland, as in Northern Ireland, there are barristers who can practice as barristers without being members of the Law Library, without being subject to the Bar Council. So that is perhaps a small anomaly that could be worked out. A similar scheme applies with regard to civil legal aid. But, Minister, I would stress that even in competition law, in a case involving the Netherlands, the European Court of Justice, in a case called Wooters, recognised the importance of properly taking into account considerations relating to the sound administration of justice in any competition law analysis of rules relating to the organisation of advocates and those providing legal services. Now, in Northern Ireland, where an independent referral bar, whereby any small-town solicitor from Cookstown or any other small town in Northern Ireland can go to the leading lights of the Bar Library in Belfast, just as any small-town solicitor in Ireland can go to the leading lights of the Inner Bar in Dublin. The Bain Commission into that recommended that allowing barristers to form associations would, by bringing them together in larger units, be a move away from the competitive model described. Barristers specialising in certain aspects of law in which there are a limited number of suppliers in Northern Ireland could group together to form a local monopoly. Well, Minister, similarly, barristers could do the same here, but even more worryingly, a big firm and the very few specialists at the bar in an area could do that. I believe that the proposals, though they seek to tackle problems which clearly must be addressed, don't actually address those problems which they seek to address, and will actually create further problems. Finally, Minister, I would conclude with an observation that these measures are being presented to the House as though they are necessary because of the IMF Troika bailout deal. In fact, I would suggest, contrary to that, they are not necessary. And I would remind the House of a quote by Pitt the Younger, who said, "Necessity is the plea for every infringement of human freedom. It is the argument of tyrants, it is the creed of slaves." Now, Minister, I don't wish for a moment to suggest that you wish to commence upon a reign of tyranny, but it is not a personal matter, Minister. There will be future Ministers of Justice. The law is something that we must frame for more than one scenario. And I would hate to see the legal profession being made beholden to any Minister for Justice. I would also hate to see the legal profession being enslaved to having to meet the targets as larger legal firms are, because it is primarily smaller legal firms and independent barristers who take pro bono cases on which our justice system relies upon. Thank you, Chairman.
Thank you, Deputy.